Good evening or afternoon, ladies and gentlemen. Welcome to this presentation by Sobal of International Family Legal Work. We've got two speakers for you today. We've got David Truex, who is a consultant solicitor in expatriate law, based in Melbourne, London, Dubai, and Singapore. He's a specialist in family law, and he's dual qualified in England and in Australia. He's an accredited mediator and family arbitration in Australia as well. I will leave you, David, to tell those attending today a little bit more about your own experiences in that field. But thank you very much for agreeing to join our seminar this afternoon at such short notice.
You're welcome, Peter.
And our second speaker is Federico Cincotta. Federico is very well known to us because he's the vice chairman of Sobal, and a very good one too. He's also the founder and chief executive officer of Cincotta International Advisory Firm. He is qualified in England and Wales and in Argentina, highly experienced commercial and family lawyer in the international field. And Federico, again, I'll leave you to say a bit more about your exploits and experience than I could do justice to. And then the third person to introduce will be Ian Burton, who again is one of the committee members of Sobal, the secretary. Ian will be acting as moderator today, and he works with his own firm, Ian Burton Legal, in the city, highly qualified corporate and commercial lawyer. Just a few words before we start about Sobal. Sobal is the acronym for Society of British and Argentine Lawyers, and it was originally founded in, I think, going back to 1997, when I was actually one of the original founding members, along with Alejandra Sadler from Argentina, who sadly died a few years back. And this was at a time that President Menem was in place. And there was a great feeling here in the UK that Britain and Argentina were really going to start doing a lot of business together, because I went to several of these functions at the time, and there was a great buzz going on in the legal community about Latin America sort of finally opening up to British lawyers. But things didn't quite go that way. We had the big crash in 2001 or 2, was it, Federico?
2001.
2001, that's right. And it went through a period of not much activity, but over the years it has continued to grow, and now I'm very proud to say that we've got a really good committee on board, and we work very hard to get to where we are, and I'm very pleased with all of those who are on board. And I think we'd like to see a lot more people joining Sobal from all sorts of areas, because the more we can have on the society, the more expertise and work that will grow from it. So those of you who are inspired to join Sobal at the end of this seminar, please feel free to download an application form and send it through, and we'd love to have you on board. So I think that's probably enough from me. I'll let Ian now take over as the moderator, and I hope you enjoy the seminar. Thank you.
Thank you, Pete.
Thank you, Peter. Thank you. Well, it's funny, when I was thinking about this presentation this afternoon, this morning, I realized I haven't actually looked at anything to do with divorce law and all the matters around it since, I think, 1990, when I was preparing for my Law Society finals, and I can remember dealing with it then. So I realized, so I'm looking forward to sort of learning and having a nice refresh, as it were, after 31 years, I realize. I think one of the things I would like to ask you both, David and Federico, is when you're looking at divorce in an international context, how do you decide which country to perhaps start proceedings in, and how would you sort of, is it sort of either, both, sometimes neither? It might be a third country. Just that was something that occurs to me.
That's a tough one.
Mm.
I mean, that question could take many years to answer in terms of how the circumstances of the case and what do the clients really want and what laws are applying.
Mm.
The first thing you need to do is get enough information about the family involved in the dispute before you can even begin to think about the answer to that question. So my starting point is to ask my prospective client all about the nationalities of every member of the family, the residences, present and past, of every member of the family, the domicile in the common law and civil law definitions of that word of every family, of the family. Where are the assets? Are there any complicated structures like trusts? There's a big list of questions you need to ask. And then you look at, where can I achieve an optimal outcome, not necessarily for my client individually, but for the family? In which jurisdiction, at the least expense, with the most certainty, and as quickly as possible, and with as much engagement by the parties as possible. In other words, letting them resolve matters by themselves through mediation, rather than being thrown onto the litigation treadmill. So you weigh up all of those matters, and being a lawyer, in the end, you're saying, where is my client going to get the better outcome? And sometimes it's one jurisdiction, sometimes it's another jurisdiction, and sometimes it can be a combination of jurisdictions. You get one of your orders in one country and another set of orders in another country. For example, do the divorce in England because you can get the divorce quickly in England, but do the financial proceedings in Argentina because the assets are in Argentina, or vice versa. So sometimes you need to mix it up. One of the big bugbears is retirement benefits, pensions as we call them in England, superannuation in Australia. It's often forgotten that in order to divide up pension or retirement benefits, you need to do that with an order in the country where the benefits are established. For example, an Argentine court cannot divide up the United Kingdom pension and vice versa. And people often make the mistake of getting divorced in the wrong country and then finding they cannot divide their pension up in the other country. So it's that's a short answer to a very long question.
Oh, that's great. That's cool. Thank you.
I'm going to answer the questions from an Argentinian point of view. So, for example, in terms of the divorce, the Argentine courts will have, in order to have jurisdiction, the applicable law, according to the National Civil Code, will be the law of the last marital domicile. That will the one that will determine the applicable law. So, therefore, if the last marital domicile was Argentina, Argentinian law will apply. However, for example, in the case of the last marital residence was located in a foreign country, the parties could file for the divorce in the foreign country and then register the foreign court judgment in the Argentine civil registry. In terms of where do I file for divorce, the international jurisdictions of the courts in private law, the National Civil Code of Argentina, again, establishes that the filing for the divorce, as well as the matters relating to the effects of the marriage, those can be brought before the courts of the last marital residence or before the courts of the respondent's spouse residence. And there you are opening a potential concurrent jurisdiction. Now, I should also mention that Argentina is a federal country and it's divided into 24 provinces. Each province, apart from having the national Argentinian constitution, each province has its own constitution and local laws. The National Civil Code will be the main law governing family law matters, but the procedure is governed by each province and will vary from province to province. So although you're going to have the applicable law will always be the national law of the civil code, the court with the jurisdiction is the provincial court of the last marriage where the residence was settled. In terms of same-sex spouses and civil partners, the same rules will apply. And in terms of property, the applicable law will be the one to the marital property governed by the where you got married. So it could be, for example, and in case of real property, the law of the jurisdiction of the first marital residence cannot be contrary to the law of the jurisdictions where the property is located. In this case, the latter will prevail. So, for example, if you got the parties married in the UK and they are domiciled in Argentina and they want to divorce, the divorce will take place in Argentina. Argentinian courts will hear that divorce. But regarding UK property, for example, the law of the UK will apply unless they have immovable property in Argentina, and the immovable property will be governed by Argentinian law. And finally, I would mention in terms of the children, you know, the law, Argentinian law provides for the right to receive alimony and child support. And again, that is governed by the law of the marital residence. But also alimony and child supports are regulated by the law of the respondent's domicile. That option clearly benefits the claimant for alimony or child support because it gives a wide range of alternative courts for him to resort to. And lastly, in terms of parental rights, they are governed by the law of the place where these rights are exercised. We have a legal principle in Argentina called the principle of court effectiveness that establishes that visitation rights must be filed before the court of the child habitual residence in order to ensure quick and effective jurisdictional protection.
Okay, thank you.
Federico, can I ask a question? That's a very interesting summary. I have to say I've done a crash course on Argentinian law today by looking at the practical law website from the United Kingdom. That's a very good summary. And that what you just summarized is exactly what I've tried to learn today in a very few minutes. And the question that I thought today, and the one that comes into my head again hearing you speak, is this. With the English couple that you mentioned, living in Argentina for a long time, say in Buenos Aires, if they have a home in England, they're going to get divorced in Argentina. But they got married in England. Will the judge in Argentina use the applicable law of England for that couple for everything?
It's a bit more complicated. We actually have a case exactly like that. The party got married in the UK. They lived 10 years, 12 years in the UK. They just moved recently to Argentina during the pandemic. We filed for divorce in Argentina. The divorce has already been issued, so they are already divorced. It also establishes visitation rights, and they have actually property in Argentina and in the UK. So actually, we could actually in terms of the property that it's based in in the UK, there are two possibilities. If the parties agree to be settled in Argentina, we can get a division of those assets in Argentina, and then you need to basically uphold them in the UK. Or we could actually say that we oppose to Argentinian law and we would like that property in the UK to be settled in the UK. In that particular case, we prefer to be settled in Argentina, because in Argentina, when you divide the assets, that's probably something that we discuss in a little short while, but you have, when you divide assets, there's you have what we call marital assets and personal assets. Matrimonial assets are those acquired during the relationship, and those are shared 50-50 each. But assets that you have acquired before the marriage belong to you. They don't belong to the couple itself. And this house, for example, was bought with money from the sale of an apartment that my client had before getting married. So if I apply Argentinian law, that percentage or the money that he used from the sale of the previous apartment will belong to him and not to the couple. In the UK, it is difficult to establish if you're going to have the distinction between matrimonial assets and personal assets, because it's to the discretion of the courts. Whereas in Argentina, you know, they have over 10 years, so it could be that the UK courts might say, actually, it doesn't matter, they are mingled assets and we need to divide it 50-50. If I'll apply Argentinian law, the amount of money that he puts from the sale of the previous apartment that he held beforehand will belong to him. So we're going to apply Argentinian law. We are happy with that.
It's a very interesting background, because I think cases like that, with the increasing mobility of people, I think will be becoming increasingly common in the future, where people are moving from one country to another, property in two, maybe more countries. And it's very difficult for the lawyers to work out which law they apply and which court is the right court, and what is fair, because as you know, Federico, the English court has this idea of what is fair for the family. And in other countries, they will say, well, what do you mean by fair? And even in England, we say, well, fair is, I mean, there was a famous case of White many years ago, where in the House of Lords, as it was then, Lord Nichols said in the case of White, well, fairness is like beauty, in the eye of the beholder. What's fair to one person is not beautiful to another person.
Exactly.
It depends whether you are the husband or the wife. And in other words, it is very discretionary in the English jurisdiction, whereas at least in a civil code jurisdiction like Argentina and much of continental Europe, you have a very much clearer view on what is likely to happen, because you have community of property or separation of property. And,
I think there's more certainty.
There's not much scope for fighting.
Indeed, there's more certainty of how assets will be allocated.
I agree. And that's the big tension in the English law, where we have had for decades, generations perhaps, the debate between whether it's better to have a system which is clear and easy to apply, so that people don't have to hire lawyers because the contract says what's going to happen anyway, or whether you have a system that says you need a judge to tell you what's fair, because what's fair is different for every family. The English, at least for the time being, and for the past, have said, well, we prefer to have the system where the judge decides what is fair. If the people can't decide for themselves, the judge will decide what is fair, and what's fair in one court might be very different in another court, or from one judge to another judge, or from a judge to an appeal court, or an appeal court to the Supreme Court. Everybody might have a different idea of what's fair.
And the other thing that surprised me a lot under the English courts is that you might have a directions hearing with a judge, and then when you have the final hearing, it might be a different judge, or the financial hearing might be different to the one of the children's. So you don't seem to have the same judge dealing with the whole matter, which I think it would simplify things. In Argentina, all these matters, they will always end with the same judge.
Well, I can give you a very good practical example from a recent case of mine, where at one of these preliminary hearings, the judge said, well, I think that the husband should pay the wife something in the range of say, £400,000 or £500,000. And at the final hearing, the judge said, no, it's double that amount. Now, how can you settle a case when two judges in the same court differ by 100% on what a fair settlement is?
Exactly.
It's a very good example of how hard it is to settle a case. And neither of the
and hence why all the cases end up in court, because there's no clear instructions
and
to what is fair.
were wrong. Nobody was wrong in the case. Everybody had a different opinion on what is fair. That's all.
One thing that I would like to ask you both that occurs to me is, are the grounds for divorce in England on the one hand and Argentina on the other, are they the same or more or less the same, or is there quite a difference? So in some cases, if a couple want to divorce, they actually wouldn't have a choice but to seek divorce in one country rather than the other, because only one country would acknowledge that they have grounds.
I think Federico's answer is probably easier than the English answer.
Yes, I'll give you the Argentinian. In Argentina, you don't need any grounds for divorce. With the reform of the civil code back in 2015, there's no fault case for divorce. So basically, either party, you now have divorce in two main forms. One is the unilateral divorce. In this process, one of the parties can file a petition for divorce against the other, and with no particular fault. And the joint divorce is where both parties apply to the court jointly for a petition for divorce, and they tend to be pretty quickly. We file during the pandemic 2 divorces in Argentina, and they are both divorced now.
That's a fairly straightforward and simple answer. And from the English side, I would need about an hour to explain it. But very briefly, we do not really have in England and Wales no fault divorce. At the present time, you need to apply for a divorce on the basis of one of 5 particular pleadings of facts. The most common one is that the other person has behaved unreasonably or intolerably, which is a very difficult thing to define, but it's very subjective, and so it's easy to get a divorce with alleging that. Or you can allege adultery, which means that you have to accuse the other person of committing adultery, which in some countries can be a very dangerous thing to do, because adultery is a criminal offense in some countries with very serious penalties. So you need to be careful about whether you allege that for a divorce, or separation for 2 years if both parties agree, or separation 5 years. So there are five grounds for getting divorced, and the most common is unreasonable behavior. The law is supposed to change later this year to no fault, but back in 1996 they said they were going to change the law to no fault, and then they changed their minds. So although we think we're going to have no fault divorce in England and Wales later this year, I'm not taking any bets on it, because the English have changed their minds before and they might change their minds again. We'll wait and see about that. But it's likely to be no fault divorce. What's that? Almost 10 years behind Argentina. Right.
Okay, well, thank you. And one other thing that as I understand it, there is the divorce itself, obviously the end of the marriage, and then there are the various financial orders and arrangements that are made. Is it possible to have those conducted in 2 different jurisdictions, or possibly with real estate you have no choice but to seek orders in the other jurisdiction, even if the main divorce is being run through a different jurisdiction? Is that a concept?
Certainly, yes. From the English perspective, it's quite common for people to get divorced in one country and get at least some of their property or financial orders in another country.
Right. Yes. I mean,
like the example I explained before. I mean, if you get divorced in England, for example, but you have a pension retirement in the United States, a retirement benefit in the United States or in another country, the English court cannot make an order about that. You have to go to the other country. And it's similar the other way around. If you get divorced in Argentina or in Australia, and you have a real property in England or a pension in England, the foreign court cannot deal with that. You need to go back to the English court. So that means you have your divorce in one country and your financial orders in the other country. That's a common scenario in English divorce. I don't know about Argentina.
In terms of, for example, enforcing financial orders in Argentina, if a foreign financial order or a judgment either pass outside the jurisdiction or in another province in Argentina, it has to be final and duly certified, can be enforced before the jurisdictions of the paying party domicile or where the defendants or the paying party domicile has property is located. In terms of if you have a foreign judgment, Argentina will admit it to be executed in Argentina's jurisdictions. There are different treaties, international treaties that will establish the proceedings for the foreign divorce to be enforced in Argentina. And in the case of if it comes from a country with whom Argentina has no treaty, we will need to see what the procedural code of each province will say. But basically, all the provincial procedural codes will establish and will admit the enforcement of a foreign judgment, provided by a process that is known as an exequatur, yes, which is basically the execution of a foreign judgment as it was passed in Argentina, and it will need to comply with certain requirements, mainly that the judgment is final and has been notified to the defendant, and it doesn't breach Argentina's public order. The definition of that could be very wide. And it doesn't oppose any Argentinian previous judgment.
And
that's very similar to the concepts that we have in the English jurisdiction, particularly in relation to European judgments, even after Brexit.
Right. And if you're divorcing in one country, but say you have a big house in the other, do you have to wait for the divorce process to have completed, to have your decree absolute, as it were, and then you go to the other country and say, oh, we have this house that we need to divide? Or can you run the two side by side to some extent?
Certainly from my experience, again, it depends on the country. In England and Wales, the financial orders are ancillary to or attached to the divorce. So you've got to have your divorce before you can get your final financial orders. That is not true in other countries. For example, in Australia, my other jurisdiction, it is possible to get the divorce completely separate from the financial orders. So you can, in Australia, obtain final financial orders to divide up the home and the pension, retirement benefits and everything else without even getting divorced, because they're not connected to each other. So what it means, for example, in English cases, you might get divorced in England, but before you've even done that, you've got your property sorted out by orders made in an Australian court or in a court somewhere in Europe or in America. It's quite possible.
In Argentina, you would need to you need to have basically the divorce in order to know the date as from which the assets will be divided. But upon the breakout of the marriage, if the parties cannot agree how to split their assets, which is always advisable to reach an agreement out of court, it's a lot less expensive, and you get to save the costs as well of the courts, which is they tend to be substantial, because it's 10% of the value of the assets and then a 10% of the 10%. So if you have £1 million house, that you need to be divided, you need to pay 100,000, 110,000 on court fees, which is quite substantial. And as I mentioned previously, in order to divide the assets, you have two different types of assets, which are the marital assets, which are the assets that both parties, the husband and the wife, have acquired during the marriage. And this, it doesn't matter who holds title to the asset, it will still consider, no matter that it might be a house registered in one's name, it will be a marital asset if it was acquired during the marriage. Those assets will be split 50-50, and even if the parties cannot agree, the judge can only split them 50-50. And then the personal assets, which are the assets that you have acquired generally previously to the marriage, those are not considered marital assets, and therefore the judge will not consider those assets as marital assets.
Okay, thank you. I realize that one obviously key thing with many divorces is the children and what happens there, both with obviously with young children, where you're looking at custody issues and also child maintenance. And I just wondered if you could both give us a brief summary of how those issues are looked at in England and in Argentina.
Well, in Argentina, the obligation to support the minors, it's mandatory for both parents, yes. Now, the parent holding custody of the child doesn't have to pay a monthly quota because it is accepted implicit that it is in the custodial status. The other party, on the other hand, is obliged to pay a monthly quota. And then the principle here is that it's based on a combination of the real needs of the children and the parents' income and ability to pay. There are two principal rulings regarding this issue, which is that the alimonies can be modified according to the changes or the new needs that the children might have, and to the increase or decrease of the income of the paying party. And the idea is that the children should maintain a standard of living similar to the ones that the parties had before the breakdown of the marriage. Generally, the courts in Argentina oblige the non-custodial parent to pay directly a monthly quota, plus as well health insurance and education for the child. As you probably know, the inflation in Argentina tends to be quite high, and this resulted in a large amount of filings to court to adjust the alimony sum. Generally, what happens in Argentina is that basically, if the father has a salary, 20 to 35% of that salary will go towards children's alimony. And sometimes what we agree is a method of pre-establishing an automatic increase for the children's alimony due to the high inflation that we have in Argentina. And a parent who fails to pay or comply with this obligation may also face criminal sanctions.
That summary would be familiar to the ears of an English lawyer. I guess the difference is that in England and Wales we have a government agency which, for most families, will assess the child support according to a formula established by legislation and subsidiary legislation. So you can go online and work out your own maintenance obligation simply by keying in the key data, such as the incomes of the parties and how often the children stay with each parent. And the website formula will tell you how much you should be paying. And that works for most people. So you very rarely in England have court cases over child maintenance like you used to have in the past, because the formula will cover most families. And you find that most families will reach an agreement. They'll look at the formula, they'll work it out, and they'll either do a private agreement or they'll register their agreement with the maintenance service, and it's done. And it rarely gets to the court. For some families who have rather more complicated financial circumstances or are rich, and you're talking about holiday homes and private school fees and things like that, then the court can come in and order more money for child maintenance, but that's for a very small percentage. So the child maintenance in England is mainly in the hands of the formula rather than the court. And Ian, you mentioned the child custody side of things. In terms of international law, the United Kingdom, of course, is party to the 1980 Hague Abduction Convention, as is Argentina, but also the 1996 Child Protection Convention, which purports to establish a global consensus in relation to how the welfare of a child should be determined, looking at the child's best interests. Argentina hasn't yet entered that one into force, but it could be applied at the discretion of an Argentine judge. So it facilitates the international recognition of custody orders and access orders.
I have a question, David, actually, in terms of, because we have a UK case as well, where they are discussing about child alimony. What would be the reasons why a judge would not follow the statutory guideline and would assume that someone has more money and then they have to pay more child alimony?
The most popular ones for diverging from the formula are there are special circumstances relating to the child. If the child has special needs, special education needs, or special health needs, or if the lifestyle of the family has been such that the child has an expectation, or the parents of the child have an expectation that this child will, of course, go to one of the illustrious English private schools, and the formula will not cover the school fees. So you've got that exception too. They're the main ones. And the other one is, of course, in international families where a child needs to travel from between countries to visit the parents or go on holidays to the south of France, which is not uncommon with families who have the money. And in those cases, the judges will order the traveling expenses of the child to be paid in some form or another. And that's all over and above the formula assessment of what the child actually needs to live. So to summarize, it's special needs, including health and education, travel expenses, and lifestyle, standard of living. There can be other reasons too, but those are the main ones that would give you more money than the formula.
And in relation to child abduction, as David mentioned, Argentina is part of the convention of the 1980s. I would just add that, for example, if a father or a mother would like to travel with a child, if they are both traveling with the child, they need to prove that they are the parent before the immigration borders. And if just one of the children is traveling on its own, or with one of the parents, the non-traveling parent has to sign before a public notary an authorization which will need to be exhibited at every Argentine border.
That's a very good idea, Federico. How long has that been the law in Argentina?
For a long, since I remember. Yeah,
really?
Yeah. Between me and my wife, for example, we both have a power of attorney to the other in case they need to travel.
It's such a sensible idea, and we don't, as far as I'm aware, have it yet in England as a matter of law. And
here it is not required.
I mean, I
In
know they have it
England-
in other countries,
Yeah.
but I know that we've been talking about it in our family lawyers organization in England and Wales resolution,
Yeah,
getting a standard certificate,
yeah,
which will be recognized internationally, so you can present it at the immigration counter when you're traveling with your child, and have maybe a universal certificate
yeah.
recognized around the world.
And,
But it
and,
hasn't
and,
been done yet.
and as well, Argentina's criminal code would punish severely both the child abduction itself, and also the denial of contact between the child and the non-cohabiting parent. Both are severely punished by Argentinian criminal codes.
So in a situation where you had a marriage breakdown and one parent takes the children, get boards of a plane and just leaves and goes back to the other country, that would cause serious problems for them in Argentina then?
Yes, certainly from the English perspective, say, for example, a person took a child from the child's habitual residence in Argentina and brought that child to England against the will or authority of the parent in Argentina. The English court would be very strong on sending the child back home to Argentina if it can be established that Argentina was the habitual residence. There are some very limited exceptions if you can prove that they're very bad for the child to go back, but they are rare exceptions, rarely used. The general rule is the English court will send back to the home country any child who's abducted.
In Argentina, happens the same. First, to leave, it will be very difficult for one parent to leave the country without that authorization. It's almost impossible. Even when I've been traveling with my children, my wife and myself, if we don't have the necessary documents, they don't allow you to take the child out of Argentina. And there were some famous case in Argentina. He was abducted, the child was abducted from the US into Argentina. He has lived for over 10 years in Argentina. And then the the Supreme Court of the province of Buenos Aires, after 10 years, no matter that he has already settled in Argentina, made friends, go to school and so on, they decided that the child should go back to the parents' habitual residence, which was the US.
And then following on from sort of the maintenance of children, what about spousal maintenance in the two countries? Is there much difference there? Where
I think so.
Yeah. I wonder, yes, if you could just speak about that, I think that would be helpful.
Federico, I mean, the way I looked at the statute very briefly, it looked to me like in Argentina, ex-wives cannot really expect to get money maybe for their children, sure.
Yeah, for the children, yes.
For the ex-wife herself, it sounds like an uphill battle to get money for her.
Yeah, but basically, up until you get divorced, you have to give alimony to your wife. But once you are divorced, you don't have to give any alimony to your wife unless extremely exceptional circumstances, and they will be temporary. The same as an economic compensation. We have you have two things in Argentina: the spousal maintenance and an economic compensation. In both cases, with the reform of the civil code, only in extreme circumstances. For example, if the wife suffers from an illness and she cannot recover. The other thing that, for example, for the economic compensation, you could only get it if you have a clear economic disadvantage as a result of the divorce. That will be in comparison, of course, to the assets and the potential income that the parties had at the beginning of the marriage, or an impediment, for example, to obtain jobs. Otherwise, the relationship is over, and you have what in England called a clear cut. In Argentina, you don't continue paying to your wife. Yes, to your children. To the children, you have to maintain the alimony and child support until they are 21 years of age, and it can also extend up to the 25 years of age, provided that they are still living with the father or mother, and they are studying and not working.
Well, it's very, very different from the situation in England and Wales. You need to distinguish a bit between what the written statute says and what the actual practice of the law is. The statute requires spouses to maintain each other after the divorce if they need money. And in practice, what that means in many cases is that if the main financial breadwinner in the family, the husband, for example, has the capacity to pay maintenance to the ex-wife, and she needs that money in order to maintain a proper standard of living, then she does have the right to claim maintenance for herself after the divorce. And the most common scenario, of course, is where there are young children and the wife says, well, I've not worked for 10 years and I'm looking after the children and the child support is not enough and I need to pay the mortgage, so please give me maintenance. And it is very common in England for a judge to order the wife to receive maintenance for a period of time after the divorce has been finalized. And that period of time can be a long period of time. In times gone by, that maintenance could go for the rest of your life, unless the ex-wife remarried. In more modern times, there have been attempts to limit the time period. So judges will say, well, you can have some maintenance until the youngest child finishes school or until you can get a job and retrain. But it's very common for ex-wives in England to get maintenance for themselves, not just for their children, but for themselves, for at least a few years after the divorce. Very common, and in some cases for much longer periods. And it's something that we discuss about, should we reform that law? The funny thing is, just across the border in Scotland, it's like Argentina. It's almost impossible for Scottish to get maintenance after the divorce.
We have a case of two Argentinians who are living in the UK and they are getting divorced. Of course, she's claiming global maintenance, which is basically what you described. But we are discussing actually that although she has not worked, she had a nanny at the time, and so she could have come back to work. And let's wait and see what the judge will say. It is unlikely.
The case is in Argentina.
No, here in the UK.
The case is in the UK.
It's two Argentinians here in the UK.
And is the case in London or is it somewhere else?
In Guildford.
Guildford is a suburb of London. I mean, the other in England, and this is not just my personal opinion, but fellow lawyers share this opinion. In the south of England, mainly London in particular, an ex-wife is more likely to get maintenance after her divorce. And the further north in England that you go, the ex-wife is less, in other words, the closer to the Scottish border that you get, the less likely the judge is to give the ex-wife maintenance.
So the advice would be go and live in Scotland or near Scotland.
Well, Newcastle upon Tyne or Northumberland, yeah, but it just seems to be I don't know, almost an intuitive thing that when I speak with colleagues from the north, they say, well, why should he pay maintenance? Why doesn't she get a job?
Yeah.
Down south, the London judges in particular still will ask the question, how can she support herself without maintenance? It's almost like a culture clash between the north and the south. Still changing slowly, but it's a remarkable aspect of English family law. Where in England are you getting divorced?
That's fascinating.
Yeah.
Hmm. Just see the check. Oh, I've just noticed that there's the chat box has just been opened, asking anybody if they wish to ask any questions. So I will keep an eye on that. One thing that occurs to me about divorce proceedings is typically how long does it take?
The question of the million. Depends on the court, it depends on a lot of factors. I have to say, for example, this divorce case in the UK has been going on for over 2 years. We have a final hearing date for November in terms of the finances. And in terms of the custody of the children, we had a directions hearing last week, and we're going to have in September, but we filed it around a year ago. In Argentina, I have found, to be honest, even during COVID, we filed two divorces. The persons, they have already been divorced. In less than 6 months, you get the divorce. They are registered with the registry. And in terms of the division of assets, we haven't started it yet. That will take probably a bit longer. I'll guess around a year maximum. And for the children's, we're going to have a decision very soon, to be honest. I'm hoping that we're going to have it actually today. But that could take, again, it depends if the case it's open to evidence or not. If they open to evidence around 9 months, for example, I guess, more or less.
Yes, that's my experience too in the English jurisdiction. The divorce, as the divorce itself, just getting the divorce should normally take from beginning to end, maybe 4 months, maybe 5 months. It's been slowed down a little bit by the COVID, slowing the court procedures down, but 4 to 5 months to the decree absolute is normal in England. And the financial case, maybe a year, maybe a bit longer, but again, slightly slowed down by the COVID backlogs. Children cases, of course, can take many, many years because tragically, people keep going back to court to ask for orders to be changed and enforced. And often children cases can last until the children are in their late teens.
We have a question, which is, how is inheritance treated in a divorce?
In Argentina, what you inherit belongs to you. It will be a personal asset and not a matrimonial asset.
Right. Yes, you
It's a
said
bit
that.
more nuanced in England and Wales, I would say. I mean, if you've received an inheritance while you are still married, or before you even got married, or if you've received your inheritance after the divorce but before the financial settlement. It all depends on when you received the inheritance. If you received it a long time ago and then used the money to buy the family home, then the fact that you inherited the money probably does not affect very much how it is divided up between you and your spouse. If you have inherited the money very recently and kept it separate and not put it into the joint bank account or joint property, then it may be treated as separate property. It's very difficult to be definite about how you treat an inheritance. If you expect to receive an inheritance but it's not yet been received, in other words, the person you expect to get the money from is still alive, that can not usually be taken into account because a future inheritance is never a guarantee. The person might decide to give the money to somebody else. So past inheritances may be taken into account depending on the circumstances. Future prospects of inheritance usually not taken into account because it's very difficult to predict.
Well, thank you. Thank you. Well, we don't seem to have any more questions from those attending, so I think it's possibly time to wrap up this presentation, unless either you have anything else that you wish to add.
I would like to add in relation to mediation and arbitration. You know, arbitration in family law in the UK, it is possible. In Argentina, it's not. arbitration I'm talking. And in terms of mediation, for example, for divorce proceedings, you don't have mediation. I'm always talking Buenos Aires province and the capital city because the process, of course, as I explained before, depends from province to province. But in the city of Buenos Aires, you have a mediation process which is compulsory. If the mediation process, that is, sorry, for the family matrimonial matters, that is alimony and division of assets. And if there is no agreement, then you can file the case in court. And in province of Buenos Aires and in many provinces in Argentina, the mediation process for the division of assets and alimony takes place inside the court, actually. So it's a meeting with a judge, mediation meeting, and then if there is no agreement, you basically, the case continues and carries on.
Right.
And just on that point, with the jurisdiction in England and Wales, for some number of years now, you cannot even start a court case to do with children or finances until you have at least tried to have mediation. And you need to get a certificate signed to say that you've tried to get things done by mediation. And only once you've done that are you allowed to start a court case. And then even after you've started the court case, there are preliminary hearings in relation to children or money, preliminary hearings, 2, maybe 3 preliminary hearings, depending on the nature of the case. And at each stage, the court will encourage the parties to try and reach an agreement. In financial cases, there's a compulsory financial dispute resolution hearing where the parties must sit in front of the judge these days virtually by Zoom, and the judge will try to mediate the case for them before they actually go to trial. So there's a strong emphasis in the English system on mediation and out-of-court settlement.
Okay. Well, thank you. Well, I see that we're almost at 4 p.m. So I think it's probably time to thank you both very much. I found that very, very interesting. After 31 years of not really looking at legal matters around divorce, I feel as if I'm now up to speed to some extent in both England and Argentina. So thank you very much.
My pleasure.
Thank you.
I'd just like to, yes. So those attending, I hope you've enjoyed this Sobal event. And if you're not already a member, please take a look at the website and send us a membership form because we would love to have you join. So thank you.
Thank you, Ian.
Thank you very much.
Thank you.
My pleasure.
Thank you, Federico.
Bye-bye, David. Bye-bye. And
thank you. Bye, Peter and Susanna, if you're still there.
Susanna.
And Liz.
Yes, goodbye. Thank you very much. That was very interesting.
Thank you.
Cheers.